Recording, got it.
Okay. Welcome, everyone. Thank you so much for coming to our Sunday seminar today. We're excited to kick off our first seminar of 2022. And for that, we're very honored and pleased to have our own Dave Bole, who's going to be leading us in a discussion of estate planning. Dave is a retired attorney, recently retired, and has spent 44 years practicing law and has had experience with estate planning and representing different estates. So without further ado, I'm going to hand it over to Dave to get it started for us. Thank you, Dave.
All right, thank you, Michelle. And welcome everybody to the estate planning seminar, which I'll sort of refer to as Estate Planning Basics 101. What I hope to do is to give you some information and some things to guide you in your thoughts and deliberations when it comes to estate planning, either yourself or maybe someone in your family, so or friends. So one of the things that I was thinking about when I was preparing for some remarks on this was I saw a Gallup poll, and they said what percentage of adult Americans have a will? Anybody have any guesses to how many people, percentage-wise?
35.
It's around there. It's 46%.
Okay,
So, to a certain extent, that's maybe surprising, maybe not surprising. But the other question they posed is what was the reason why a lot of people didn't want to deal with preparing a will? And any thoughts as to what one or two of the primary reasons were?
They don't want to deal with their death.
That's one of them.
About dying.
Yeah. And the other one is just, I'm sorry, Dwayne?
They said they don't think they need one.
Well, that's true too. Another one was just simple procrastination. People just put it off for the reasons that, you just mentioned. So, but that's also the old adage is, don't wait to plan your estate because it could be too late. And that's good advice for people. So a lot of folks just as you indicate, just want to deal with it. And it's too complicated, it's too messy. They don't want to deal with their own mortality. So, but that's really the responsible thing to do, is to really plan your estate, because you're doing your family, your loved ones and friends and so forth a benefit by doing it, instead of leaving a messy situation.
Dave, are there people who just think, I don't have anything, so I don't need this?
Say again?
Are there people who think, well, I don't really have very much to leave, so I don't need this?
Yes, there's people that do that, and we'll get into that. People who just don't want to bother with a will because they think either their assets are not that significant, or if they die without a will, it's going to end up with their family anyway. So why do I need a will? But we'll touch on that. So when you start thinking about, and when Michelle asked me if I'd be interested in doing this seminar, the first thing I thought was, boy, estate planning, that can be a very broad and a very complex topic. And indeed it is, depending on the circumstances of a person's situation. If there's substantial assets involved, if there's just a simple basic thing, it all depends on circumstances. So you want to be aware of what the circumstances are and start to plan accordingly. So the first thing you want to do is what do you want to do with your estate planning? What's the whole purpose? What's the objectives of estate planning? And typically what we look at is you want to ensure that your wishes and your family needs are met. You want to dispose of your assets according to your wishes. You want to protect your family assets and property. You want to plan for your own needs. And you want to minimize taxes and expenses. So those are the general goals. Anybody have any thoughts as to what else, what what your goal would be?
You should also mention if people have children under the age of 18, that, the wills have to designate a guardian for them. You don't want to leave that decision up to a judge.
Okay, you're stealing my thunder, so we're gonna get to that. We're gonna get to that a little bit down the road here. But those are your basic goals and what you really want to look to do. So the first thing I would tell people when it comes to estate planning is size up your estate. By that I mean make an inventory of your assets, make a list of what they are, particularly how they're titled, and we'll get into that. And also what the approximate value of the asset is. Now that's going to change, obviously, as circumstances may dictate and as time goes on, but size up your estate. So what are the kinds of things you want to look to do? Well, you want to look at your bank accounts, your stocks, bonds, mutual funds. Do you have a life insurance policy? Do you have a retirement account? Do you have a business? And if you have a business, do you have a succession plan in that business? Do you have real estate? Do you have personal property like vehicles, collectibles, coins, artwork, personal property? Do you own a boat? Do you have jewelry? And even your digital assets, that's important too. So that's just a sort of a basket of the types of things you want to look to do and look for. So put those on a spreadsheet. You want to put those on a piece of paper, and you want to, make sure that those things are in front of you. So when you start doing estate planning, you can be advised accordingly. The other thing you want to do preliminarily is you want to start thinking about who you're going to go to if you need estate planning documents put together. And typically that's going to be an attorney. And depending on your circumstances, you may just get a general practice attorney who does, basic wills in the states. Or if it's more complicated and complex, you're probably going to want somebody who specializes in estate planning that may have information about taxes and trusts and things of that nature, depending on the circumstances. So, you may know an attorney. If not, you may have an accountant that you deal with, or a professional financial advisor that may know a person who deals with the estate planning matters. So that's an important thing for you to think about. Now, what are the important documents in estate planning? And generally, there's 3 or 4 of them to start with as basics. And depending on complexity, there may be others, but we're talking here about, the basic estate planning documents. And so you're talking, first of all, about a will. You're talking about a durable power of attorney, an advanced healthcare directive. And in some cases, depending on a person's situation, they may want to put their funds and their assets into a revocable trust. And we'll talk about those. So why do you have a will? Well, you want to have a will because it's going to direct exactly how your assets are going to be disposed of upon a person's death. It's also going to provide for a personal representative or someone known as the executor to basically transfer those assets in the will. And that's important because, when you die without a will, you die in a situation called intestate. And when you don't have a will, your wishes are not particularly taken care of, and you don't have a personal representative in the estate that's named. And in that situation, you may have to go down to the surrogate's court. You may have to get a court order to appoint an administrator to administer the estate for somebody dying without a will. And your wishes may not be necessarily protected. Although you die without a will, there is a statute in New Jersey called an Intestacy Statute, which directs how your property is going to be distributed without a will. So for example, if there's a surviving spouse, the spouse likely will take. If there are adult children and there's no spouse, the adult children will take. So in a lot of instances, the money may end up going to those people. But the fact is, if you wanted to give, and I'm giving you an example, $5,000 to Uncle Waldo because you like Uncle Waldo, you would put that in your will. But if you died intestate without a will, Uncle Waldo's not going to get that money. If you wanted to give, money in your will to a charity, and somehow you don't put it into a will and you don't have a will, and you die intestate without a will, that's not going to fulfill your wishes. So basically, dying intestate is basically a potential problem. And if you don't have a personal representative, as I said, you're going to have to go down and get an administrator appointed to administer your estate. And they're going to have to post a bond, meaning to secure the faithful performance of their services. And that's going to be a cost to the estate without a will. On the other hand, if you have a will and you appoint an executor in the will, usually the testator, that's the person who signs the will, is going to waive the bond so that you don't have to incur that expense for the executor to be bonded. So those are some of the issues that come up with and without a will. Now, you can have a will, of course, prepared ideally by a professional, so it's done correctly. But you can also have a will that's valid in New Jersey called a holographic will. Now, what's that? A holographic will is a will that's prepared by the testator, him or herself, in their own handwriting. And that can be valid, but it's got to be witnessed and it's got to be put together in a way that, again, you name a personal representative, an executor, and so forth. But they are valid in New Jersey. They got to be witnessed by at least 2 people. Ideally, they should be notarized. But if they're not done properly, they won't be, the holographic will not be accepted generally by the surrogate. And you may have to get down and get a court order, and that involves a lot of time and expense under the circumstances. There was one particular case which I can recall where this particular woman, she was a widow, and she had 2 daughters, and she was particularly close. I'll call them daughter A and daughter B. And daughter A was particularly close to the mother. She lived with the mother, took care of her needs, and the mother wanted to remember her in the will and give her the house that the mother lived in. Daughter B was sort of estranged and didn't really pay too much attention to the mother, but the mother took care of her needs in certain respects. And so the mother, she wanted to have a will prepared after many, many years. And she went to an attorney, and the attorney drafted up the estate documents. The will would have provided for the house to be given to daughter A, and really didn't provide too much for daughter B because of the circumstances. And the attorney sent the documents over to the mother, draft documents for her to read over and look at. Didn't hear anything back for almost a month, and got a little concerned, put a phone call in. The daughter said, Mom's going to get around to it. She's going to look it over and we'll get back to you. Nothing happened. Another 2 weeks later, another call goes in. Daughter answers the phone. Mom's going to get to it. She's looking it over, thinking about it. So nothing happened, and all of a sudden the lawyer gets a call from the daughter that Mom was just taken to the hospital, and she had some serious health issues. So sure enough, mother's taken to the hospital. They work on her, and she's taken into intensive care. And a few days later, unfortunately, she passes away. She never signed the will, but a couple of weeks later, after her passing, the lawyer gets a phone call from the daughter A, and daughter A says, I was going through Mom's papers and I found a handwriting of hers, and I'm sure it was hers because I know Mom's handwriting. And she wrote out a will in her own handwriting, and she signed it and she dated it, and she put me in there to inherit the house. And my sister, she didn't really put much in there for her. And she appointed me as executrix of the will, which is a holographic will because it's in her own handwriting. Well, lo and behold, the lawyer tried to get the will sent down to Hackensack at the surrogate's office. This woman lived in Bergen County. And the surrogate rejected it because the holographic will wasn't witnessed by two disinterested witnesses, because obviously she's not a lawyer. She didn't realize the implications of that. So what they had to do was to make an application to the court to have the holographic will authenticated, proven to be truly her last will, and the daughter and so forth had to testify about the handwriting and so forth. I'm not sure what the outcome of that particular proceeding was, but when you think about it, it was a big deal because she unfortunately put it off, as we discussed just a few moments ago, instead of coming to grips with it and signing the will, didn't get back to the attorney. And now her wishes, she wanted her daughter to have the house, and she wanted the other daughter, not to unfortunately participate in the estate, but because, she didn't sign the will that the lawyer had drafted up, which would have spelled it out in detail, and did it with a holographic procedure in her own handwriting, that would have made a big difference depending on the outcome, because if the court found that holographic will in her own handwriting was invalid, she dies without a will. And guess what happens to the house? That house doesn't go to daughter A outright. It's going to end up being under the Intestacy Statute, and probably is going to have to be split between daughter A and daughter B, which was not mom's wishes. So that's just an example, and that's a true story, by the way. That's an example of what can happen under the circumstances that we discussed. And, if she had been a little bit more diligent in getting this thing done, maybe none of that would have happened. So when we talk about a will, let's talk about a typical will, which is sort of a mom and a pop will. Mother and father, married couple, and they've got some kids. Typically, a will pass assets that are individually titled. For example, if Aunt Jenny owns a house and it's in Aunt Jenny's name alone, then the will that'll be a probate asset, meaning it goes down to, it'll pass to someone else after the executor signs the deed to transfer that asset to somebody. So what do we mean by probate? What happens is when a person passes away with a will, that will typically is probated with the surrogate's court in the county in which the person had passed away. So let's take, for example, Bergen County. That's a surrogate's court in Hackensack. The will is presented to be probated. The will is sent down there by the executor typically. They go in there, they fill out some papers, bring in a certified death certificate, they bring in identification, they pay maybe $150, and the will is probated. But what does probate mean? Probate has been defined as the court supervised procedure of administering a deceased person's estate, authenticating a will, appointing an executor, paying the debts and taxes, and distributing the assets. So that's the process, simply put, where the will is authenticated as a legitimate, true last will and testament of the decedent. The surrogate passes upon that, authenticates it, and appoints, according to the will, the executor and gives the executor the authority to administer the estate. And that's typically what the probate process is. And then the executor will go upon his or her duties to administer the estate and to transfer the assets accordingly. What happens if a person who passes away, as some people still do, have a safe deposit box in the bank? Well, under those circumstances, the safe deposit box used to be inventoried and frozen by the New Jersey Inheritance Tax Bureau, so that you couldn't take any assets out of there. The executor couldn't, without the inheritance tax folks showing up and inventorying the assets, because, you know, people would stick valuables in there, diamonds, perhaps cash in some cases. They would have the stock certificates and so forth. So the Inheritance Tax Bureau used to inventory those boxes, but they don't do that anymore. So typically an executor, once he or she is qualified, would call the bank, call the financial institution, and then be guided accordingly, show up, show them the letters testamentary issued by the surrogate, appointing them as personal representative executor, and then typically you can open up a safe deposit box. So what's in typically a will? Well, we take the mom and pop will that I mentioned, married couple with kids. The typical will provides typically for directions as to funeral expenses, last illness expenses, and payment of those types of debts, and any burial instructions. And some people, depending on their religious and cultural background, may have very specific burial instructions that can be put into a will. I had one client many years ago who loved the ocean, and he specifically wanted his remains to be cremated and taken out on a boat out in the ocean near Point Pleasant. His ashes be strewn in the ocean way out there. But that was his wish, and actually the executors ended up renting a boat, chartering a boat, and going out and doing that very thing to fulfill his wishes. A little unusual, but you know, there are certain situations, depending on other circumstances, that people have particular wishes to be fulfilled. The next thing after you have the typical clause for payment of debts, expenses, and taxes is the personal property clause. And we talked about the inventory that you have in your estate. So do you want to give away certain articles of personal property? Do you want to give Aunt Antoinette the diamond ring? Do you want to give Uncle Waldo, you know, that painting on the wall over there? I've had folks come in and actually have maybe 25 articles of personal property that they wanted to be put into the will to specific individuals. That gets a little cumbersome, but what you can do is, and there's a statute that provides for this, is a memorandum of personal property. So in your own handwriting, you can lay out what you want to do in terms of giving articles of personal property to various individuals, to various people. And you can attach it as part of your will, not in the will itself, but you know, put it together with the will. And so that is perfectly legitimate. And there's, as I say, there's actually a law or statute that regulates how that's done. And typically, if you have an attorney put a will together, he'll show you, he or she will show you how that can be done very simply without putting all of that stuff in the will. The will typically provides for the appointment of an executor and typically an alternate executor, because if you want to appoint the executor and something happens to that particular person, you want to have a backup, so-called designated hitter, I'll call it. You want that person to be able to step into the shoes of the executor. And the executor's responsibilities, we'll talk about that. The executor's responsibilities are very broad. They're given statutory powers to act, to basically marshal the assets of the estate, talking about the inventory we just did. They take those assets, they pay the expenses, they pay the taxes if appropriate and if required, and pay the expenses of medical bills and so forth. And eventually once that's taken care of, they distribute the assets of the estate to the individuals who are the beneficiaries named in the estate.
David,
Can I
Yes.
ask you? What's your question?
my question, well, with that memo with the personal property, does that have to be witnessed or notarized, or can it just be, you know, just in your handwriting?
No, it can be in your own handwriting. It doesn't have to be witnessed or notarized.
Okay, thank you.
So the next thing after the preliminary provisions of the will, you know, you'll see people give bequests. to perhaps different people. I give $5,000 to Uncle Rodney. That's an outright request, so there's no strings attached, there's no conditions attached to it. But you know, if that bequest was for $5,000 to Uncle Rodney, if he supplies me with ice cream for the next year, then you got a condition attached to it. So there are different ways in which a bequest can be made. People make charitable bequests, and we'll talk about that in a minute. So that's typically what you can see in the will. If there's a particular article that you want to give, other than putting it in the personal property memorandum, if somebody owns a vehicle, for example, they have to put that in the will. They want to give this vehicle specifically to a named beneficiary. That would be laid out as a form of a bequest in the will. Now, the last provision, and again, I'm using the simple will of a husband and a wife, is what we call the residuary clause. That's all of the rest, residue, and remainder of your estate, real and personal, wherever situate and whatsoever, you put into the residuary clause. And basically what I'm saying is that's the so-called magic language that goes in there. But the bottom line to that is whatever is left over after you've given bequests, after you've paid the taxes, you've paid the expenses and so forth, that goes into the residuary clause. And typically, if you have young children, what you're going to see is a clause to the effect that I give my property or the residuary estate to my descendants who survive me per stirpes. It's a fancy legal term which basically says that by representation. So for example, if a married couple has, let's say 2 children, and those children end up, getting married and having their children, in other words, a testator's grandchildren, and something should happen, unfortunately, to one of the children, but leaves those children, the grandchildren, in its place, then those grandchildren will step into the shoes of the parent by representation per stirpes and inherit their parent's share of the asset. So you'll see that language in the typical standard will for kids, youngsters, underage. You might also see a residuary clause where it's broken down, maybe not if children are not involved, but in specific instances where individuals are involved. And we'll get into talking about how to designate that. But there may be percentages in the residuary clause, depending on who the beneficiaries are, if it's an institution, if it's an organization, or if it's individual. But that's typically what's known as a residuary clause. Now, there's other testamentary trust provisions that can sometimes go into a will. And when I say testamentary trust, this is a type of trust that you'll see in wills, and people want them in their wills to protect certain situations. And it's called testamentary because it's in the will. It's not in a living trust, which is called an inter vivos trust or a revocable living trust. And we'll talk about that in a few minutes. But the first thing you want to talk about is, let's say, young children, as was just brought up before. Frequently in a mom and pop will where there's young kids underage, you probably want to put in what we call a minor's trust. And that trust provides for the care and well-being of the infant. So in the example where unfortunately mom and dad aren't around, they pass away and they leave young children underage, you probably want to put in a trust so that that money is put into a trust for them. A trustee is named to manage the funds until the child reaches a certain age. And the money can be paid out for the child's welfare, support, medical expenses, and the like. And so when a child reaches a certain age, it could be age 21, it could be age 23, 24, whatever it might be. The money then is paid out to the child, either in stages or outright. So it could be they get a certain percentage at age 21, at age 25, they get another percentage, and maybe the balance when they get older. So it depends on the circumstances of the family, how you want that to be taken care of. But that's what we call sort of a minor's trust. And the trustee has an important responsibility to manage the funds, to invest the funds, and to account for those funds during the minority of the child. And usually that's supervised by the surrogates court over a period of time. You know, every family has, not every family, but a lot of families have kids with that have issues. And there's always a concern about what to do with one of those child or children. So I had a case some years ago, a situation, a client where he was a widower, and he had two stepchildren. And unfortunately, both of them had substance abuse problems. They were in and out of rehab. And he was concerned about leaving his estate to them because they were concerned that they were going to be using it for the wrong purposes and so forth. So he actually set up a trust in his will where the kids could not get the money if something happened to him unless they passed a rigorous drug screening program, were basically clean, and there were a lot of different stipulations and conditions in there. And it was to be paid out to them in stages or in installments. At a certain age, they would get a certain percent, provided that they passed the drug screening test and so forth. He actually named and would name a trustee to administer this trust. And I didn't envy that person, but you know, it was a real concern that he had because if the kids didn't pass the drug test, they weren't going to get their share of the estate. And this particular individual was an animal lover. And so he put a default provision in there that if, you know, one of the kids didn't pass the drug test, the money would go to the ASPCA, Society for the Prevention of Cruelty to Animals. He loved dogs and animals. And so he wanted that share to go to that particular charity. So again, that's just an example of situations that, you know, they do come up, as we know, in families where you're trying to do the right thing, but you also don't want your estate to go to the wrong purposes. You also run into issues, you know, with special needs children, right? Everybody's seen these things, I'm sure, where, you know, somebody has a child with autism, someone has a child with Down syndrome. And so what do you do in that situation? Well, you can put into the will a trust provision for a special needs trust. These can be rather complicated, and, you know, person's well advised to talk to an attorney or who specializes in this kind of trust. But the whole purpose of a special needs trust is really two purposes. One is to provide the support for and the welfare and medical expenses and care for that particular child. And the second thing is to insulate the inheritance from outside creditors, or for that matter, not to disqualify that particular child from public assistance. So for example, if the child is receiving public assistance benefits and suddenly inherits money under a will, that money is protected from being attacked or from being reimbursable to the public agency who's providing assistance. So again, these types of trusts are very complex. They've become more complex in recent years. They're regulated. There's some tax provisions involved. So a person would be well advised to speak to an attorney concerning setting one of those up if it's appropriate. You know, the other issue that can come up is what we call a bypass trust or a credit shelter trust, and that's marital planning. And what happens there is as a particular individual, again, we'll take a married couple, one particular spouse can put a certain amount of money into trust, which is a credit shelter trust or a bypass trust. And what happens there is that particular trust provisions are the money in the funds in that trust can be used to support the surviving spouse during his or her lifetime. The principal can be invaded if necessary for that purpose. And then upon the surviving spouse, when that person, he or she then passes away, the money is then distributed to the ultimate beneficiary, which typically could be the children. And it doesn't get taxed. So there's a method of estate planning to avoid taxation. Again, that gets a little bit more complex, but it's known as a credit shelter trust or a bypass trust. And now that the federal exemption, which we'll talk about in a few minutes, is relatively high, that's becomes in certain situations less necessary, but nevertheless, it is an important estate planning tool. There's some miscellaneous considerations in will preparation, and I'll just touch on them briefly. There's a situation where sometimes during the lifetime of the individual who's preparing the will, he or she has got to give his child a loan. And sometimes the child doesn't repay the loan. So I've seen that happen, as maybe we all have. So you can put a stipulation in the will that maybe his or her share of the estate, the amount of the loan that was not repaid gets deducted from the beneficiary's share. And that's basically done to equalize if there's several children involved, for example, and you want everybody to get an equal amount, then, to order to equalize it and not give preference to the child who was given the loan, that can be put into the will. Actually, I've had people come into my office on a different note and actually didn't want to give their spouse anything in the will, believe it or not. They basically wanted to disinherit a spouse. And in New Jersey, at least, you can't do that. You can probably put a clause in the will that you don't want to give anything to the spouse, but it's not going to hold up because there's a statute in New Jersey called an elective share. And the spouse, the disinherited spouse, so to speak, can make a claim against the estate. It's not pretty, that's for sure, but you can actually do that. There's a very complicated formula called the augmented estate. And it's basically a claim against the value of the estate, 1/3 of the augmented estate, which is a formula that's put together, which is well beyond what we're going to talk about here. But just be aware of that situation if you know anybody or circumstances lend itself to that kind of situation. It's rather unusual, but it does happen. Disinheriting or unequal distributions to people in a will, particularly kids. There's some families just have kids that they don't want to give any money to for whatever particular reason. It's a difficult thing. But there's actually clauses that can be put into wills that basically say that if anybody tries to challenge the will, tries to set it aside, tries to otherwise challenge the amount of money that he or she receives as a beneficiary under the will, that they're basically forfeit their interest in the estate. And there's a clause that goes in there for that purpose. But, the courts are reluctant to enforce those kinds of clauses. They're loath to do that. And the reason is because they want the person who may be disgruntled or objects to the will to have their day in court and not be left out. Unless, of course, it's a totally frivolous harassment technique that the person is bringing forth. But that's a fact-sensitive issue that a court would have to decide. But, it's something that, does happen, and there's clauses to that effect in certain types of wills. So when do you want to make a change to a will? Typically, if there's any kind of a major life event, you want to review your document to make sure it's up to speed. And by that, what you want to do, for example, there's a marriage, there's a divorce, there's a remarriage, there's a death, there's a birth of a child or a grandchild. You want to make sure that your estate planning document, the will, is up to speed. And you can do that by a document called a codicil. And a codicil is basically an amendment or a supplement to the will. So for example, if taking the example before, if you wanted to give $10,000 to Uncle Waldo in your original will, and then Uncle Waldo turns out to be not such a nice guy, and you're not too happy with Uncle Waldo, and you want to reduce his share of the estate, you can do that by a codicil. And you can simply, make certain provisions in the will, change them, reduce them, add them, as the case may be. And usually a codicil makes some minor changes in the will. If there's going to be a substantial change in the will, sometimes it's better just to redo the will all over again. And that's not a problem, because the attorney would draft up the will, which by definition would revoke the original will or terminate the original will, and then the new will would simply take its place. So people also in the will can give, obviously, and do give charitable gifts and bequests to organizations, to nonprofits, and to religious organizations as well. And I'll put in a plug right now for our own Second Reformed. We have a heritage fund, as we probably all know about. And over the years, we've been lucky because people have passed on, have remembered the church in their will. And the Heritage Fund has been a very important part of the church. But, people can give it to all kinds of charities and nonprofits, as we are aware of. But what you want to just be aware of is a couple of things. And your executor probably has to be more aware of this than anybody. And that is, anytime a testator, the person who is making the will, gives money or bequest or percentage of the estate to a charitable interest, the New Jersey Attorney General gets involved. And so you just have to notify the Attorney General. Their office basically acts as an ombudsman, if you will, to watch over the administration of the estate, to make sure that all of the T's and all of the I's are crossed and dotted, and the estate is being administered accordingly. So people can give for a simple bequest. I give, X many dollars to the Second Reformed Church of Hackensack, its Heritage Fund, and that's fine, and that's terrific. And the Attorney General really doesn't care if it's done in that manner, because, as long as the check is issued and the church gets its money, that's all they're concerned about. That the charity, if it's not the church, then it's maybe something else. Then, as long as the Attorney General is satisfied that the money's been paid and the receipt has been received, it's not a problem. Where it gets a little more complicated is if somebody leaves the charity, whether it be a church or a nonprofit, in the residuary clause as a percentage of the estate. Then it gets a little more complicated, because the executor then typically has to prepare an accounting of the estate to show that at the end of the day, after all of the taxes and the expenses and all of the other issues with the estate have been satisfactorily taken care of, the assets have been accounted for. And so the Attorney General's office requires, a fiduciary accounting to be prepared, submitted to them, and then if they approve it, they sign off on it, then fine. It typically will be paid at that particular point in time. But that also is a process, and it can sometimes be a little bit of a lengthy process. But that's just a little primer on charitable giving. And that's not to say people shouldn't consider that in their will, but the executor just has to be aware that that's what's part of the process in charitable giving. Remarriages, just looking here at the time, the remarriages, those are always potential issues. John and Mary are married, John and Mary get divorced, John and Mary remarry. The kids of the marriage, the original marriage, get a little concerned about where the inheritance is going. The best thing to say there is that basically you should take care of talking about this up front and making the appropriate arrangements for estate planning as best as you can. If a prenuptial agreement is involved, then so be it. That can be prepared, but that's a discussion you would have, with your potential spouse and an attorney, perhaps if necessary. Anybody know if I said the word fiduciaries? Anybody have any idea what that means? Fiduciary is a term used of a person in a position of trust. And in estate planning, when we talk about fiduciaries, we're talking about, in the case of a will, an executor. We're talking about, in the case of a will or a trust, a trustee. We're talking about a guardian, if necessary, that's in a will, and an agent in the case of a power of attorney. And basically, those types of people are entrusted with the obligation of doing the highest degree of fidelity in the best interests of the principal in the case of a power of attorney, and in the will in the interests of whoever the beneficiary is. So that's an important consideration when you select a person to serve in that particular role, or if it's not an individual, if it's a corporate trustee or a corporate executor. All those folks who are fiduciaries have to act in the best interests of the estate. So I want to move on quickly over here to the second type of document, which is the durable power of attorney or the general power of attorney. And we've probably all heard of that particular term, but a power of attorney basically is a document where a person called the principal appoints someone else, who is typically called the agent, to handle financial affairs it can no longer do because of incapacity, perhaps, or simply because they can't do them for one reason or another. And there's different types of powers of attorney. There's a general power of attorney. A general power of attorney is a document that basically sets forth the obligations of the agent. It can be as simple as managing a checking account, can be more complicated, managing a person's estate. The general power of attorney basically takes effect and will continue on until someone becomes, for example, incapacitated, or someone revokes it, the principal revokes it and terminates it, I don't want it anymore. Or if the principal passes away, then the power of attorney terminates. There's also a durable power of attorney, which is a little bit different. A durable power of attorney survives a person's incapacity. So even though they sign a durable power of attorney today, it still continues on if a person becomes incapacitated, and the agent is still authorized and continues to act. There's also one called a limited power of attorney, and that's simply, it's not giving a person broad powers to do anything and everything, but instead allows them to do only a specific act. Typical example might be, and I've seen this and been involved in it a number of times, somebody buying and selling a house, they can't be at the closing, so they appoint somebody to sign the papers. And that's the only thing they want them to do. They don't want them to do anything else, simply a limited power of attorney. And then there's what they call a springing power of attorney, which takes effect only as if and when a particular event occurs. So somebody could sign a springing power of attorney today, but it doesn't become effective until, let's say, the principal becomes incapacitated, and then the agent acts at that particular time. One thing I would caution everybody on is if you're going to have a power of attorney involved, check with your financial institution or your bank, because they have their own particular forms, and sometimes they have their own peculiar requirements. So even though you have a valid power of attorney drawn up by an attorney, sometimes the banks want to see it on their own form, and they want to see it notarized with a raised seal instead of an attorney notarization. So I've run across that on a number of times. Privacy waivers, what are they? Those are, typically if the power of attorney provides the agent with authority to make certain medical decisions on behalf of the principal, then you want to get the principal to execute privacy waivers so that the medical provider can talk with the agent about the person's medical care and treatment. Advanced Healthcare Directive, that's also commonly referred to as a living will. That provides instructions to a healthcare provider on the types of life-sustaining treatments you want or don't want if you're unable to communicate that yourself through incapacity. And I'm showing just here a document that we used to use in the office, which is an advance directive. And basically it's called advance because a person basically is executing the document while they're competent, while they can make informed decisions about their own future care and treatment. And it gets a little complicated and complex, but it takes care of things such as life-sustaining treatment. Under what circumstances do you want that or don't you want that? It talks about pain control, cardiac arrest, pregnancy representative situations. And it appoints a healthcare representative, namely a person who makes those decisions. And again, it's not the medical healthcare representative who's making those decisions, but it's basically a person that is carrying out the wishes that the principal had put on paper ahead of time when he was competent, he or she was competent to make those decisions. So that's the advanced directive. So those are like the three things that you want to start with as the basics with estate planning. People sometimes also want, instead or in addition to a will, a revocable living trust. So what's that? That's a particular document where people create a legal arrangement through which assets are held for a beneficiary during their lifetime. And it's revocable because it can be changed, it can be amended during a person's lifetime. What happens is, you appoint a trustee in the trust to manage the trust and to basically distribute the assets, much like a will, but it's done through the vehicle of the trust. The person who creates the trust is called the settlor or the grantor. He or she can also be the trustee and be the beneficiary of the trust as well. And the basic advantages of a revocable trust is it avoids probate, but we'll talk about that in a second. And it also provides for privacy. A trust is not filed with the surrogate's office, much like a will is. It's just handled internally, so it doesn't become a matter of public record. It also avoids the necessity of getting tax waivers. If the estate is subject to a taxable event, you have to get waivers from the Inheritance Tax Bureau. You don't have to do that in the case of a revocable trust. There also is a situation involving an irrevocable trust, which gets a little more complicated, but a revocable trust you can change or amend during a person's lifetime. Once a person passes away, the assets are distributed through the trust and it becomes irrevocable at that point. But you can also set up during the person's lifetime a revocable trust, with an irrevocable trust, I should say. And that means that you can't really amend or change the trust. Once the assets are put in the trust, you don't have any control over those assets at that point. But again, that's a little bit more complex. Talk to your attorney about that if that's something that you want to take care of. A number of years ago, my aunt and uncle retired and they moved to Florida. And they were down there for a number of years. My uncle passed away and my aunt came back to here in New Jersey to be closer to family. She came to me and threw all these documents on the desk and said, help me out, what is this all about? And sure enough, it was a revocable living trust because one of the things you have to do when you have a revocable living trust is you have to put your assets and retitle all of your assets, whether it's a house, a bank account, stocks. So that's something. And that's what she did when she was living in Florida, because the attorney down there said, you know what, probate down here is so time consuming and expensive and takes a lot of time. Put your assets into a trust. That is not necessarily the case here in New Jersey in terms of probate, because as I mentioned before, you can probate a will fairly simply, inexpensively here in New Jersey without the necessity of having a trust. But again, that depends on one's personal circumstances. So just be aware of the option of a revocable living trust. How we doing on time, Shireen? I got 1:54.
Yeah, we're at 1:54, just about almost an hour.
Okay, I'll try to breeze through a couple of other points and then we'll call it a day. Gifting, people gift out of their estate for different purposes. Obviously, one is very simple. You know, you want to remember somebody who's been kind to you, who's done a lot of good things for you. And people with substantial estates do it for tax minimization or tax avoidance purposes. But in this year, 2022, a person can give up to $16,000 to anybody, tax-free, no gift tax necessary to be filed. So for example, you can give it to an adult child, you could give it to siblings, you could give it to a grateful friend, and you can do it without filing a gift tax return or incurring a tax. And again, this is also, be aware there's a federal tax exclusion for gift tax purposes, which is up to $12 million. Currently, that amount is on the table to be reduced to $6 million when it comes to gifting. So the current exemption level, just want to double check here. So gifts can be used to be paid to institutions directly for educational purposes. They can be paid to a medical provider. As long as it's paid directly, then you don't run into any gift tax issues with respect to that. A gift to a spouse is basically unlimited. There's also something known as the GST, which is a generation skipping tax. That gets complicated if you're giving money to somebody who is a generation or two removed from the person giving the gift. You can run into some issues there. So talk to a tax professional before somebody wants to deal with that. Inheritance taxes, very briefly, you know, in New Jersey, up to 2018, we had two forms of death taxes. We had an estate tax and we had an inheritance tax. And it used to give rise to the expression, you know, it's nice to live in New Jersey, just don't die in New Jersey. So basically, the legislature in 2018, they saw a lot of people, you know, as probably for a lot of different reasons, leaving New Jersey, migrating out of the state. So they eliminated the estate tax. They said, we're going to get rid of that. But lo and behold, they didn't go the full boat. They kept the inheritance tax in place. And so today we still have a New Jersey inheritance tax. So what's that? The inheritance tax basically is broken down into classifications of beneficiaries. It starts off in terms of degree of kinship to the decedent. So Class A beneficiaries, those folks are spouses, children, grandchildren, stepchildren, mutually acknowledged children, and so forth. And a Class A beneficiary, if you have that in a will, any of those type of folks, there's no tax imposed on that kind of class. Class B was eliminated way back in the 1960s. It doesn't exist anymore. Class C are brothers and sisters and others. There is a tax imposed on that, and there's certain exemptions that apply. Class D beneficiaries are aunts, uncles, cousins, nephews, nieces, things like that. There is a tax imposed on that, and there's certain exemptions that apply. So it goes up from 11% on the low end taxes up to 15 or 16% taxes to the New Jersey inheritance tax. Class E beneficiaries are nonprofits, charitable organizations, religious organizations, and there's no tax on a Class E beneficiary. You know, gifts or when you file an inheritance tax return, one of the questions they ask is, did the decedent make any gifts within 3 years from the date of death? So sometimes, depending on the nature and the circumstances, they treat that as a gift made in contemplation of death. And if they find that it was, they throw it back into the estate for inheritance tax purposes. So you just need to be aware of that. In your will, you want to be sure that you put in a tax clause. By that, I mean, you know, is the beneficiary going to pay, if the inheritance tax is due, is the beneficiary going to pay that as his or her share of the estate, or is it going to be paid out of the general estate funds, the residuary estate? And that becomes important. You ought to talk that over with the attorney who's preparing it, because that can make a big difference depending on the size of the estate, who gets what, and who's paying the taxes. So you want to be sure that there's a clause in there. Typically, if there is no tax clause in a will, then the default provision is the inheritance tax is paid out of the recipient's share of the estate. There are other things we can talk about here, but we're running slow on time here. I would just tell you, the main thing is concern yourself with how an asset is titled. Very important, because not everything goes through the will. Typically, as I said, assets that are titled individually will pass through the will, through the probate process, and the executor will, for example, if there's a house involved, the executor will sign a deed over to pass that house if it's individually titled in a person's name. But not all of your assets go through the will. So for example, if you have an asset, and I'll take a house again, that's set up as joint tenants with the right of survivorship. Let's say A and B own a house as joint tenants and right of survivorship, and A passes away, B automatically takes title to that house by operation of law. It doesn't go through the will. If there's a tenants in common situation, what's that? The tenants in common means, let's say A and B own that same house, but they own it as tenants in common, and something happens to A, he dies. That 50% interest in the house that A had goes through his will and is distributed to his beneficiaries, and B owns the other 50% interest in the house. That's called tenants in common. And that would be a probate asset. So that would go, at least under A's interest in the house, that would go through A's particular estate or will. Tenancy by the entirety, that's the same house we're talking about, but it's owned by a married couple. They own it as tenancies by the entirety. What does that mean? Again, if A passes away, and then his spouse, the surviving spouse, is going to inherit title to the house. That's not going to be a probate asset, because by operation of law, that automatically happens the way it does. Remember that retirement accounts, life insurance, annuities, they pass on to a named beneficiary. And if there's no named beneficiary, contingent beneficiary, it could end up passing to the estate, or it could end up passing to a default beneficiary in certain cases, like a brokerage house like Fidelity or Vanguard. They may they will give it to the surviving spouse if there is one, or adult children. So just be aware that you want to have your beneficiary's name up to date. And trusts, obviously assets transfer according to the terms of the trust, which was established while a person's living. So one final thought, designating beneficiaries. You want to make sure your beneficiaries are up to date. You want to put in alternate beneficiaries to make sure that if something happens to the primary, then you have a secondary beneficiary. And you want to name beneficiaries either by name, Mary Smith, or by relationship, Mary Smith, or my wife, my spouse. Makes a big difference, because depending on the circumstances, if somebody forgets to name or to take somebody off a designation, and they divorce and they still have that person's name on there, that person may end up receiving, let's say, the proceeds of a life insurance policy, because the person who passes away forgot to take that person's name off. So you got to make sure if it's done by name or by relationship to you. So those are some of the major considerations with estate planning. One thing I'll touch on just very briefly, another couple of minutes. Life insurance, we all know about life insurance and what the purpose of that is. I'm not a life insurance expert, and I'm not going to get into that, but just to advise that speak to a competent licensed broker who deals with life insurance. We know about the term life insurance. I think the younger you are, the easier it is to get the life insurance, and you can get a fairly good sizable policy with a relatively small premium, but as life goes on and people get older, that premium can increase, but that's your biggest bang for the buck, which is term life insurance. And again, you have to size up your responsibilities. You know, do you have a mortgage? Do you have a car loan? Do you have different kinds of obligations, college tuition? What happens then if somebody passes away, you know, mom or dad unfortunately passes away, who's going to pay all those bills? That's where life insurance comes into play. This whole life policy, that's a bigger premium, builds up cash value in the life insurance. So if you terminate the policy at some point, you get the cash value out. But as some people say, you know, if you're going to get cash value life insurance, don't die young, because it's a bigger premium and you haven't really built up that much cash value in the policy over that period of time. Life insurance, in addition to that, can be used as a estate planning tool. People with very substantial estates often use life insurance to pay if they're concerned about death taxes. So you put those into an irrevocable trust. Somebody passes away, the life insurance policy is paid, and that amount of money can be used to pay the taxes instead of, you know, going into the estate assets and minimizing those kinds of assets. So in summary, those are some of the major points in basic estate planning. Keep in mind your assets, how they're titled, how they're going to be transferred either through the will or outside of the will because of the way they're titled. And it's a good idea to prepare a letter of instruction to your heirs, you know, where certain things are, where your will is, where your other important documents are, the deed to your house. Your digital assets, how are they going to get into those particular things, the passwords, the usernames, and all that good stuff. So it's a good idea to put a letter of instruction and to, you know, make your heirs that are aware of it, and to have conversations ahead of time to ensure that your wishes are taken care of and are fulfilled. That about wraps it up.
Thank you so much, Dave. I don't know if we have an opportunity to entertain a couple of questions. Just a reminder that this session is being recorded, so not to share any personal details, but are there any general questions?
Well, I want to say thank you, Dave, and thank you for clearing up the thing about the digital assets. I wasn't sure what you meant by that, but now I got it, with passwords and things to like online accounts and such.
Absolutely, Dwayne. That's a very good point.
I have a question. How long are the wills good for? I know that, as you mentioned, you want to try to keep that up to date, but say you did something 15 years ago, it's still validated at the courts?
A will is as good as long as it's not revoked or changed. So if somebody drafted a will, and believe me, there's plenty of them out there that haven't been looked at in 15 years, it's still valid.
Okay. Thank you.
Can I ask you a question? What happens?
Sure.
What happens when your lawyer retires?
You know,
What are you
I can,
recommending to replace you?
yeah. Well, typically, if a lawyer retires, the client can call the lawyer, and the lawyer may have a recommendation as to who to use. In my particular case, people do once in a while call, and I'll tell them, I'll give them a recommendation as to who I think is appropriate, depending on the circumstances.
And
But that's,
what about any files that you might have had? What happened to all of those?
well, a lawyer by law has to keep his files or keep records of the files at least for a period of 7 years. And in my particular case, I actually have a warehouse where I keep files down there, and I got some in my garage. But in the case of wills, I always made it a practice to have the client sign a statement in the office that I gave them the original will, I gave them the original healthcare directive and power of attorney. And I kept a copy in my file because typically you can only probate the original of the will. And if the original will is misplaced or lost by the client, they typically have to start over and get a new will prepared, unless you're going to try to probate a copy of a will, but that gets time consuming and expensive. And, you know, it's something you don't want to have to deal with.
I have a question about gifting to your children. I believe you said that it's not a problem with federal income taxes, but with New Jersey, if you give in excess of $16,000 in a year, that could be taxable. If you give across state lines, what happens then? If you give to somebody in New York or California?
Well, let me let me just clarify the point. So you can give up to $16,000, let's say, to a child.
Right.
If you give more than $16,000 to anybody, a child or anybody, you may have to file, and again, I'm not a tax expert, I'm just telling you from my general knowledge, you may have to file a gift tax return, but you don't have to pay a tax. And the reason for that is we all have an exemption right now up to about $12 million. The federal tax exemption is for estates up to $12 million. So you can gift money up to that amount during your lifetime. It's a nice problem to have, you know, gifting that amount of money. You probably have to file a gift tax return, which is, I think, Form 709. But you don't necessarily have to pay a gift tax for that particular gift. So all the way up to $12 million, you can gift during your entire lifetime. You can gift that amount of money to different people. That doesn't include the amount of $0 to $16,000, which you can gift each year. You can gift that amount of money without filing a return, without paying a tax, without anything.
Now, I was talking more in terms of New Jersey state taxes. Are there any taxes there?
Well, there is the inheritance tax, if that's your question. There is the New Jersey inheritance tax.
No gift tax.
But there's no gift tax in terms of that's concerned. That's a federal tax, per se.
All right, thanks.
Can I say something?
Sure, go ahead.
I just want to let people know that I'm in training with an insurance company. So if you have questions about life or term policies, you can get in touch with me. And if I can't answer the question, as I say, I'm in training, but if I can't answer the questions, I can get answers for you about index, universal life, whole life, and term.
Okay, thank you.
Thank you for letting me say that.
Yeah, I have a quick question. So if you have no children and you have a will, next of kin, you still have to list beneficiaries because next of kin is considered what or who?
Well, if you have a will and there's no children, then you'd want to name who you want to receive as a beneficiary in the absence of that situation, that the children.
How does the death tax work in New Jersey versus the inheritance tax?
Yeah, but if one of you goes, the other just.
The death tax is the inheritance tax.
Okay. Thank you.
There's no estate tax, as I had mentioned, they did away with that. So the only death tax right now in New Jersey is an inheritance tax.
And there's an amount on that also, right?
Yes, it goes in graduated amounts, and as I mentioned, it goes in accordance with classifications, Class A, C, D, and E. And depending on what class the individual or the beneficiary falls in, there are certain exemptions from the tax up to a certain amount, and then the tax kicks in at as low as 11% up to 16%, depending on the class. For example, a Class D beneficiary, which I believe is uncles and nieces and nephews and folks like that, they're going to get hit with the highest tax because of the degree of kinship being more remote than, let's say, Class A beneficiary, which is no tax at all.
David, according to my experience over, umpteen years as a realtor, very often if someone passes away, the person who's inherited the property needs to have a market analysis of the house at the time of death to be given to whoever is handling the estate attorney or whoever is handling the estate. Sometimes they ask for an appraisal, which I can't do, but I can do a market analysis. And very often that's all they need. What is your advice on that?
If the estate is going to be subject to the inheritance tax and the house is going to be includable on the inheritance tax return, the best thing is to get a certified appraisal. Sometimes you can get a market analysis, as you point out. I've seen it done both ways, a market analysis. I've seen some people just take their assessed value, which is given on the postcard. Everybody gets a postcard in February each year of what your assessed value is, but that's not necessarily, as we know, the market value.
It's wildly inaccurate.
For inheritance tax purposes, I think the best thing to do is to get a market analysis from someone like yourself, Barbara, or get a certified appraisal, because they will ask for that. The inheritance tax people will ask for an appraisal to justify what the market value is.
Dave, I was going to ask if you have a will drawn in the state of New Jersey, for example, but then change your state of residence to some other state, are there issues with that later on, or do you need to have the will transferred to your new state of residence? How does that work?
Very good question, Shireen. I would say that the will generally valid where it's executed, as let's say it's in New Jersey, and then somebody moves to Florida. There may be an issue in terms of probating that will, not because of the substance of the will, but because of the execution requirements. For example, New York requires a will to have 3 witnesses to it. New Jersey only requires 2 witnesses. So there might be an issue. You'd have to talk to a local attorney in the state or the jurisdiction that a person's moving to out of New Jersey to see if that presents an issue or not. So that's come up from time to time, and that's where my advice is to people. Basically, talk to a local attorney if somebody retires and moves to another state. Have your will looked at, not so much in terms of the substance of what's in the will, but the execution requirements and whether that presents an obstacle to have it probated at some point.
Okay, thank you.
Quick question regarding, so let's say, for example, in our case, we have no children, and let's assume we're at the point where we have to go into a permanent assisted living home or situation. And I've heard stories about how you have to turn over your assets, but is there a way, or how would we find out if you can turn over enough of your assets to accommodate your living, but still leave others something? Is that a possibility, or how would something like that work out?
Yeah, Dwayne, that's a very good question and a very common question. And typically it can get very complicated. And I usually, not to dodge the question, I usually refer to an attorney who specializes in that kind of asset protection, trusts and so forth. People often ask that question in terms of eligibility for certain things, Medicare, Medicaid, I should say, and stuff like that. And it gets very complex, and it's probably beyond the scope of what we're discussing here. And so I really would think that the best thing to do is to speak to an attorney who really specializes, and that can get sort of complex because there's look back periods in terms of how a trust is set up and whether or not, the regulatory authorities would look back in terms of what's taken out of the estate versus what stays in the estate.
Okay, thank you for that, Dave. And I do have one other follow-up. As we have heard about planning your financial security, one of the things that I want to encourage all of us to consider is planning your homegoing services as well. Things that you would want to have happen at your funeral services or at your memorial services. So it makes our job a little easier and gives you a chance to let your family just enjoy your life instead of having to stress out trying to figure those things out in the moment. So if everybody will make an appointment with either Pastor Anna or myself, we can take care of that for you. And it's free of charge.
Say it's free, but I bet there's strings.
We have the form.
We have the-
There's a form that Sister filled out, yeah.
I mean, if you want to tip me when you come, Marcia, that's fine. I'm not gonna say no to your money, but
Tip Anna.
everybody else is free.
Is there time for one more question, or is there one more question? All right, well, I wanted to thank everyone, and especially Dave. Thank you so much for spending the time with us today, and for a very, very informative and worthwhile presentation. I think we all learned a lot. And thanks everyone for spending this afternoon with us. And we look forward to having other seminars during the course of the year. We'll get the information out and word out. But again, thank you all and have a wonderful rest of your day. Thank you.
Thank you.
Okay, very good.
Thank you, Dave.
Thank you for joining us.
Our attorney. I have